Thank you for joining me. My name is Rebecca Smith, and I'm an attorney here in San Antonio, Texas. Today, we're going to talk about keeping the entity separate or maintaining corporate compliance. The purpose of today's discussion is for informational purposes only and not meant to be specific legal advice. It is also current as of the recording, which is September 28th of 2022. As far as keeping your entity separate, this becomes important if you formed an entity on the state level. You filed for a limited liability company or you have a corporation, and you are in the process of keeping your entity in good standing with the state. It is absolutely imperative that you treat your business like a business. I tell folks to kind of treat it like your favorite second cousin. You need to keep that separation between your personal activities and the business activities. Treat your entity like your favorite second cousin, and you make sure that you keep all the transactions at arm's length. For example, the commingling of funds. Commingling of funds is where you mix your personal expenses with the business expenses or vice versa. Just like you wouldn't expect your favorite second cousin to pay your personal mortgage bill, do not pay your personal mortgage bill out of your business banking account. That would be an example of commingling funds, and it is prohibited. When I say keep all your transaction at arm's length, just like you wouldn't hand your favorite second cousin a loan for $20,000, right? You would expect for there to be a writing, a promissory note, and a promise for repayment. Now, while these terms can be very friendly between yourself and the entity, if you do need to loan your company money, you can certainly do that, but it needs to be a formalized writing. It needs to have repayment terms. There needs to be interest charged. It just as if you were loaning money to someone who you know very well, but you would still expect a writing. You certainly wouldn't hand that amount of money over without having a writing. And the same is true with the dealings between yourself and your business. Failure to do so can result in what we call piercing the veil or allow an attorney, a plaintiff's counsel, to establish alter ego theory. This means that they will, as a portion of a lawsuit or through discovery, attempt to prove that you didn't treat your business like a business, that you treated your business like your personal piggy bank. And they will ask the court to consider stripping the entity of its status because it's a sham, or if it's a jury trial, allowing for a jury instruction to allow alter ego theory to be established. If they're successful, they will disregard that corporate veil and be able to come after you personally for the debts and obligation of the business. So it's very important that if you do have a LLC or a corporation, that you make sure that you treat your company like a company, you maintain corporate compliance, you keep track of the business, you have operating agreements. If you are doing loans, that you make sure that everything is at arm's length transaction. And when you make important decisions about your business, you put them in writing in a form of a meetings minutes. And all of this goes to prove against counsel to show that it is not alter ego theory, that you did in fact treat your company like a company. Thank you so much for joining me. It's been a pleasure speaking with you.